Good afternoon, everyone. My name is TOOMELA. I am an attorney from Estonia, from a neighboring country. And I would like to tell you a little about legal protection of data and legal protection of data from a very specific aspect, which concerns monitoring of employee email in a working relationship. I would like to start with a broader view. You might recall that maybe 4 or 5 years ago, data protection, legal data protection, was really not an issue. It was kind of, you had it somewhere. It was a topic that's been discussed, but you didn't really feel that it's a burning matter. And then, within the last, say, 3 or 4 years, there have been many scandals, many leaks, many hacks. Let's just put it like that. You had the WikiLeaks, then you had the hacks from the East. Let's just put it like that, from the eastern side. Yeah. Of course, not as nothing been proven, but well, there are serious allegations that our countries were hacked from the East. And with the boom, with the blossoming of social media, there have been also been many, many cases where people's profiles, social media profiles, have been hacked. Identity thefts have been occurred. And people have been presented by another person as their identities. So all of these things, all of these leaks, all of these hacks, and these issues and problems have made people more conscious about their privacy and their personal data. And what it really comes down to is actually privacy. And now going into more specific, you might want to ask, well, okay, we get it, privacy, but what's privacy got to do with employment or work? This is work. Whatever is private, whatever the worker or employee is doing with the spouse, that's private. So it has nothing to do with work. Well, it's really not that simple anymore. Because, see, personal data legally is a very wide concept. And just to give you a perspective here, everything, all the data that pertains to a person, that identifies a person or allows identification of a person, is personal data. Name, sex, body image, the beard, yeah. Everything is personal data. That is basically inevitable personal data that the employee actually drags along to the employment relationship, but it goes beyond that. Just previously I mentioned social media. Today, well, we all have Facebook accounts. Many of us have Twitters, Instagrams. It's not just the personal stuff that we post there, that we comment there. Many of our employers have Facebook accounts, Facebook profiles. We like our employers' Facebook profiles. We tweet about what we do at work. Our friends, yeah, acquaintances, whatever, whoever in Facebook like our employer on Facebook. And the data really gets mixed. Everything gets mixed. And going into specific my topic now, what I'm about to tell you, when we're discussing emails, I'm pretty sure that with all of your employees, maybe some exceptions, they have one email account for everything. And usually it's the employer domain, related account. The personal stuff, work-related stuff, everything goes through one email. Again, things get mixed. So with the employment email, employer usually has to take into account that it contains personal information on top of other personal information that gets processed during the employment relationship. But at the same time, the employer still must be able to conduct business and ensure compliance, because things have to be in order, business has to be conducted. So you have these two kind of colliding interests, as you might say, and it's all about finding the fair balance between those. Fair balance. And for finding that fair balance, employer always has to act responsibly. And now going further, I will explain you exactly, on the basis of some examples, how to monitor, how to process employees' email data correctly, and give you some examples of situations that are allowed and situations that are not allowed. So first and foremost, got it. An employer who wants to act responsibly here, in order to ensure the fair balance, must establish a work email. If in your company you haven't really established an email, a work email for an employee, and the employee actually uses personal email for employment duties, then under no circumstances are you allowed to monitor or to check that mail. And what I mean by work email, I'm not meaning that you have to have your domain, like, let's say, stephanie@coca-cola.com, yeah? It can't be a Gmail. It can't be stephanie@gmail.com. But it has to be communicated to the employee that this is your work email. That this is your work email. It can be coca-cola@gmail.com. But don't use it if you're not Coca-Cola. Only use it if you are Coca-Cola. Otherwise, you get in trouble with the intellectual property law. However, only that is not enough. Second, I strongly advise you to set out specific internal rules that regulate use and monitoring of employee email account. In 2007, there was a case in the European Court of Human Rights, Copland versus UK. And in that case, the facts were as follows. An employee was in charge of college property, of university college property, and it had a work email, work telephone, and internet provided by the employer, by the college. But there were no internal rules in place. Also, the UK law at the time did not regulate monitoring of employee email. And what the Court of European Human Rights said was that since there was no regulation whatsoever, none from the state side, none from internal side, then monitoring of that email account, work telephone, also internet, were not lawful. And it was recognized in that case that the employee's right to privacy, according to Article 8 of the Convention, European Rights Convention, Human Rights Convention, was infringed. So it's very important that you have the work email account set up, and you also establish the internal rules. And third, communicate these rules clearly to the employee. This relates to transparency. And transparency is also a very important principle of personal data law. The employee, a person whose data is being processed, has to know about it. What this means, for example, is that if you do have a legal ground, for example, a suspicion that infringement or violation of employment duties has occurred, and you do monitor for that reason the account of the employee, then you must inform the employee of that. It's not like, okay, he might be a thief, go to the emails, found proof, and that's it. And you don't never really inform the employee, and just later you found some kind of other reason, or you use it for some other reason to attack that employee later. You have to let the employee know. Of course, if there's a theft involved, then you can also inform the police, but you also have to know, let the employee know. What else? Some of the things that I want to stress out here. If you don't have these rules in place, then there are some very, very strict grounds under which, pursuant to certain laws of certain member states, you might still gain access legally to employee email. But these are exceptions. And mostly these are very limited. So definitely encourage you to set up internal rules. I'm not a Latvian lawyer, actually, but I did some research on the Latvian law for this presentation. And the interesting thing is, whereas most European countries and the data protection authorities of most European countries have stressed the importance of these internal rules, the Latvian authority actually has not. And the Latvian Data Protection Authority, according to my knowledge, has basically set out two principal options, regardless of the existence of the internal rules, under which an employer may monitor the mail. One is that there is suspicion of violation, and second, if the employee is absent and the monitoring of these emails is essential for conducting business. These two grounds. So it's kind of interesting to me how Latvia has not really put an emphasis on these internal rules. But, well, you never know. It may happen in the future. At least currently it's kind of strange to me, actually. I've also seen the guideline of the Latvian Data Protection Inspectorate's, Data Protection Authority's guideline regarding processing of personal data in the employment relationship. And it's kind of a 10, 15-page illustrated kind of document, a lot of pictures in that. Whereas in Estonia, we have the same document, processing of personal data in employment relationship. We have a 120-page with small, strict principle writings documents. So the data is much more wider there, and there's a lot more principles and a lot more things that are relevant in Estonia that the Latvian authorities seem to not really care about. So I don't know if it's good or bad. At least I would say currently Latvia is in kind of unclear state. But that's maybe just my opinion. Second thing I want to point out is that in any case you do monitoring, you should never go beyond what is absolutely necessary to achieve your purpose. Meaning, for example, that if you want to verify, for example, that whether your accountant, who's an employee, has sent out an email on time, and your client received the invoice was sent with that email in time. Based on, for example, on that client's claim that it was not able to pay the invoice because it came in too late. First of all, what you should do in that case, I think, is contact that client and ask that client to forward that email to you that the accountant sent out. If that for some reason is not possible, then turn to that accountant itself. Don't go to the emails at first, turn to that accountant at first and ask that accountant to send that email. And if that is not possible, then you go and monitor. Then you go to the email box of that accountant employee and check that email. So if you go to monitoring, it has to be absolutely necessary. You should always prefer solutions where you don't go check those emails directly. And also, when you go through the emails, let's say you monitor the emails, then obviously you're going to see a lot of stuff there. And just by looking at the senders, just by looking at the titles, the subjects of the emails, you're going to realize that obviously many of them are not employment related. Well, if you see an email which subject is "Hi honey," obviously there's a reason to presume that it's not work related, especially when the sender is the wife of that employee. So you should really try to check only work-related mails. And also, if you do somehow accidentally click a wrong email, let's say a personal email, you have to close it immediately. And again, you have to inform the employee for transparency that you discovered that mail. So that is basically what I mean under the second point here. Never go beyond what is necessary for legitimate purposes. So now these internal rules that I previously discussed about, I would like to describe you some of the opportunities which you can use these internal rules. First of all, you may think that, okay, let my internal rule be so that I will completely forbid any private communication. It's the easy way out, I agree. But it's not that simple legally, because, again, in many countries, for example, in Latvia, as I have understood, your local data protection authority has stated that the employee always has a certain right, a certain amount of right to privacy in the employment relationship, and you cannot deny that privacy completely. That's the position of the Latvian Data Protection Authority, as I have known. In Estonia, in Lithuania, that forbid will be completely valid. And in that case, the employee will be completely forbidden to use any the account for any personal purposes. And if it does so, then it risks itself that some of the personal information gets out to the employer. Now, you don't have to have a complete 100% forbid. You may also regulate that, okay, you may use it for both. It's normal. We all do it, yeah? But a good way in that case would be have a special folder for personal stuff. Just say that, okay, all the emails coming in are work emails, but all the special ones have a special folder, and say that's private, that's personal. Then you will check it. There's nothing you have to look at there. Third, automatic forwarding, definitely what I recommend if an employee is out. You can also regulate the procedure in that rule, of course. And I would not recommend any regular monitoring, like, okay, I will go and check every month or once a month. I would rather stipulate some grounds, for example, like if there is a reason to presume that an employee has committed a violation, if you are out of office, things like that. So not a kind of exhaustive monitoring, regular monitoring. For simple monitoring purposes, I wouldn't recommend that. I'm not saying it's definitely illegal, but at least considering the transparency, considering the minimum principle of minimalism that we discussed, not go beyond what is absolutely irrelevant, then I wouldn't recommend that. Again, an employee may agree that another employee who's a good friend checks the email. And last but not least, of course, when the employee leaves, it's good to have rules for that in place too. How would all that communication, work-related communication, then be transferred upon termination of the employment contract? Now, the case law is very slim, but I will shortly discuss one landmark case that just a couple of months ago came out of the European Court of Human Rights, and that is the Barbulescu case. And I guess, when circumstances. Got it. I guess they're trying to say my time is up. It is actually, but I'll make it short. So the circumstances are as seen here. What's important? Important is that employee, in that case, had a Yahoo Messenger for responding to client's request only. That was a work-related messenger, only for work. And that was clearly communicated to the employee. Private use was completely forbidden. So that rule was also in place. And what happened? Employer checked it and found out, whoa, a lot of personal stuff, like 45 pages of personal stuff. Communications with fiancé and brother, and contract was terminated. And of course, the employee was not satisfied, claimed violation of Article 8, privacy. And in that case, what the court said, it's not really unreasonable to presume that the employer wants to verify what the employees are doing during the working hours. And also what was important there was that during the case, no emphasis was really put on the content of these emails, of these private emails, but rather the fact that there was a forbid, there was a rule in place, and that was violated. And in conclusion, the court said, fair balance was there, no violation, everything in order. So, employer won, Romania won. It proves that it's not really one-sided. Maybe you heard that I kind of explained everything from the employee side. No, it really is about the fair balance. If the employer has acted reasonably, responsibly, then it also has the right to presume that the employment duties are fulfilled and has the right to monitor it accordingly. And I will leave you some final thoughts. Unfortunately, I don't have a great marketing speech as my previous presentators here had. I would just say that I am an attorney from Estonia, We also have Eversheds. We are a global brand. We also have an office in Latvia, Eversheds Pitans, a full-service law firm. So wherever you are in need, please contact them. They also have a data protection team. And wherever you have any issues in Estonia, yours truly will help. So thank you very much.
Thank you. Thank you. Thank you for really practical suggestions. I guess the takeaway points are really clear. There were a few questions on the slide though, but maybe you can ask them direct, because I would like to keep us both popular, because I know that the other group has actually finished earlier, is already having some wine. So before it's over,
everybody just took
I
the
only have
questions
one
back.
question to you. Well, what if the IT manager, unbeknownst to me as a CEO, is reading that work email? Am I responsible? Is this employer reading others' emails if IT manager does that? Well,
If IT manager does that,
is it my problem or is it his?
well, of course, it's your problem too.
Okay.
You have to make sure that the
Too bad.
IT employee does
Guys,
not
have policy in
monitor
place
it.
also for the IT manager. Thank you so much.
Thanks.
One announcement. The only way you can qualify for those prizes at the end is that you go to the Valmo stand and beep this thing. More than 100 people have done that. And if you complete the survey, 33 people have, then you qualify for the prize draw. So if you do that, you have a chance. Go have some wine. We start at 5:20 in the big hall.